Holly Walker.
Thank you, Mr Speaker. Well, it's interesting to have inherited this bill as another member who wasn't present in 2009, and it has indeed been languishing for a very long period of time, and as we've heard, first drafted under the previous government after a comprehensive review by the Law Commission. But, Mr Speaker, it's a shame that it's being considered in the way that it is, having been suddenly resurrected from languishing at the depths of the bottom of the order paper, because it is a piece of legislation that deserves quite careful and considered consideration by the House, in our opinion, and it shouldn't be rushed into law after languishing for years just because it has suddenly become politically expedient for the government to do so. And actually, Mr Speaker, we consider in the Green Party that there are some serious risks in passing this legislation, which I will outline shortly. Now, we know, of course, that this bill has been, or the resurrection of this bill has been prompted by the recent botulism crisis at Fonterra, which put our biggest export markets and indeed our whole international image and reputation at risk. And the government wants to be able to conduct an inquiry into what happened at Fonterra under more modern and better rules to apply to that inquiry than the ones that currently exist, which are over 100 years old. And that's fair enough, although they could have actually done it a long time ago and avoided this unseemly haste, which just makes it look like New Zealand, again, can't get its act together in this area. But, Mr Speaker, the Green Party supported this legislation at the first reading because we also recognise the need to modernise and update the legislation governing the way that inquiries are conducted, because that legislation is over 100 years old, older indeed even than Chris Okenvold. However, we have reached the conclusion that we need to abstain today in the second reading, and our support, if it's given at any future stages, is by no means guaranteed because we have some serious concerns about the powers to compel witnesses to disclose information that are contained in this bill, and I want to talk about that a little bit. So, as we've heard, the bill provides for two kinds of inquiries to be established, both public inquiries, which includes royal commissions, and also government inquiries, which are driven by ministers, and either can be established for the purposes of inquiring into any matter of public importance. And the bill then sets out the terms under which such inquiries will be able to be conducted and to operate, such things as how members to the inquiry can be appointed, what the reporting requirements of the inquiry are, the ability of that inquiry to call witnesses, to hold hearings, and crucially to compel the disclosure of evidence. Now, the concerns of the Green Party focus on the powers granted to all inquiries by this bill, but in particular what these will mean in practice when employed in government inquiries, which are to be driven by ministers. Now, in general, the bill promotes a high level of public transparency and disclosure, which we support, and it appears to operate under an assumption that information will be made public unless there's a good reason not to, and we do appreciate that the Labour Party intends to bring an SOP to clarify this. But we have serious concerns about the powers granted to all types of inquiries, government and public, to compel witnesses to hand over evidence and documents and other materials, and I refer here to clause 21, powers to obtain information. An inquiry may, as it thinks appropriate for the purposes of the inquiry, require any person to produce any documents or things in that person's possession or control, or copies of those documents or things. And it goes on to talk about how copies can be made, and they must provide information to the inquiry and can verify that by statutory declaration. And we can also look at clause 23, which says an inquiry may, on its own initiative or on the application of another person, order any person to disclose to any person participating in the inquiry any specified document, information or thing that that person has produced before the inquiry. So that's quite a serious level of compulsion that inquiries will have once this legislation is in place. And it comes along with quite serious offences and penalties. So if we look at clauses 30 and 31, every person commits an offence who intentionally fails to attend the inquiry or fails to produce any document or thing required by order of the inquiry or destroys evidence. And a person who does any of those things and who commits an offence against that section may be liable to a fine of up to $10,000 and could have contempt against the inquiry proceedings initiated against them in the High Court. Now, let's just think about this in relation to a high-profile recent inquiry, which is the Henry inquiry into the leak of the Kitteridge report into the GCSB. Now, presumably, under this new legislation, this would be a government inquiry, and it would have all the powers set out under Section 21 to compel persons to appear before the inquiry and to provide evidence to that inquiry. Now, members will recall the Henry inquiry did not have the authority to compel anyone to do anything, but because the Prime Minister had indicated to his ministers that he expected them to comply, it was able to obtain ministers' phone and email records. However, it should not have obtained the email and phone records of a Member of Parliament, although it did, nor should it have obtained the phone or swipe card records of a journalist, although it did. And those matters have now been referred to the Privileges Committee, Mr Speaker. And while this inquiries bill does provide some protections for privileged information, including parliamentary privilege, it's not at all clear that parliamentary privilege would be sufficient to prevent, under this legislation, if the Henry inquiry had been conducted under this legislation, it's not clear that would be sufficient to prevent the inquiry from compelling an MP to disclose his or her emails, or indeed from compelling a journalist to disclose his or her sources. So this afternoon, Mr Speaker, the Green Party has sought clarification from Minister Tremaine's office, and we haven't received a response, and possibly that's because that was the wrong minister, I don't know. But we do need to hear from whichever minister is in charge about this very important issue before we can support this bill in any future stages, because while we're very much in favour of openness and transparency, I need to be very clear, Mr Speaker, that we acknowledge the rights of MPs to operate independently from the government, for their communications with their constituents to be protected, and we acknowledge the very important right of journalists to protect their sources, Mr Speaker, and we have serious concerns that the bill may inadvertently actually undermine these rights. And it seems as though, under this legislation, if the equivalent of the Henry inquiry was held, it could have compelled Peter Dunn to release his emails. It could have compelled parliamentary services to release phone and email records and swipe card information, and it could have compelled Andrea Vance to reveal her source. And if she refused, which I'm sure she would have done, because she's a very principled journalist, she could have been pinged with a fine of up to $10,000 and had contempt proceedings initiated against her in the High Court, Mr Speaker, and that's very concerning. So we need some response from the government about this. Is this intended? And if not, we need to see some changes to the legislation to clarify that. Because it also seems to be nothing in the legislation that would protect MPs from having to disclose details of communications with their constituents if they were compelled to do so by an inquiry. And that begins to impinge very closely on our ability as members of Parliament to carry out our role. So it seems, Mr Speaker, like these issues just simply weren't anticipated by the Law Commission, by the previous government, by Parliament when this was first debated, nor by the Select Committee. And I suppose that's not surprising because they didn't have the topical example in front of us, of them that we have in front of us. But given that topical example and given the current political context and the fact that ministers will be the drivers of government inquiries under this legislation, we are very concerned about these provisions, and we will need some compelling assurances from the minister and probably changes in the committee stages by supplementary order papers in order to be able to support this bill any further. And I urge my colleagues from across the House actually to take a close look at the issues that I've raised this evening and seriously consider whether the bill needs amendment in these areas and clarification on these important issues before we can proceed. Mr Speaker, in principle, modernising the laws governing public inquiries is a necessary and positive step, and a strong emphasis on openness and transparency in those inquiries is encouraged. And that's why we supported the bill at first reading and why we would like to support it through its remaining stages. But there are very fundamental constitutional and democratic principles at stake on the matter of what the bill can compel witnesses to disclose to inquiries that I think need very careful consideration by this House and by this House in committee when it gets to that stage before it proceeds any further.
Kanwal Bakshi.
Thank you, Mr Speaker. It's my privilege to stand and speak on the second reading